Good morning, everyone. Let me call our 29th public meeting to order. I'm chair of the commission. I would like to, first of all, call roll of the commissioners who are in attendance. Commissioner Bluestone.
Here.
Commissioner Calderon.
Here, good morning.
Commissioner Ellison.
Present.
To law enforcement.
Commissioner Kajrosian.
Here. Good morning, everyone.
Commissioner Luma.
Present. Good morning.
Commissioner West.
Good morning. Present.
Commissioner Wynn.
President, good morning.
We have a quorum. Commissioner Sherry has indicated that she's unable to attend today. And members of the public, we also welcome your attendance. We will, at this point, move according to the items in the agenda in order. Let's start with item number 2, approval of the minutes. Is there a motion to approve the minutes of our September 8th meeting?
So moved.
Thank you, Commissioner Kajrosian. Is there a second to that motion?
I'll second.
Any comments or questions with regard to the minutes?
She needs to hear that those
Commissioner-
people who purport to be
Let me call for a vote on approval of the minutes. Commissioner Bluestone,
I approve.
Commissioner Calderon,
I approve, yes.
Commissioner Ellison.
here.
Approved.
Erosion, you just,
Yes, I approve.
Commissioner Luma,
Approved.
Commissioner West,
Approved.
Commissioner Wynn,
Approved.
and I also approve. The minutes are unanimously approved with those in attendance. Moving next to the executive director report. Enrique, you're up, please.
Thank you, Madam Chair, and good morning, commissioners. Let me just start my presentation in a minute. Just remind members of the public that we will not be taking questions, even though the Q&A function is enabled in the webinar. We'll monitor those questions, and we remind people that they can always send questions to us directly, as indicated in our website. There's 3 different contact information, depending on whether it's a media inquiry, a certification inquiry, or any other questions you may have. So let me also just share my screen, commissioners, just to go through a very brief presentation, as I have done in the past, to give you an update of where things stand. Can everybody see this? And just as I have reported in the past, I'll start with our ongoing efforts of certification for comparison purposes, and also in order to track the records that we have, how they have been fluctuating lately. I have included what I reported to you, commissioners, back in September, the last meeting, the September 8th meeting. The data at the time was as of August 31st. The data as of yesterday stands in the second column of this report, or of this chart. And you can see that we've made quite a bit of progress in the certification category. We've accepted almost 900 records that from the city of Boston that were pending at the time, and we have now received them and processed a great deal of them, or frankly, the majority of them. We've also made progress in addressing a number of people that had been conditionally certified as of last September, and many of them had 90 days from the submission of those applications for certification come due. There are certain conditions that have to do that they were given 90 days to complete. And you can see from the 840 at the time to now the 603 people that are still conditionally certified, that there have been many people, many individuals that have moved in the certification category. We continue to make progress on those individuals that merit further review. And as I had reported to you in the past, there's a number of individuals that now have become or are falling in the not certified category. That number stands now at 57 compared to 15 at the time. As has been reported in the past, some of the individuals in the not certified category, I would say a majority of them have to do with training. Training that was not completed as part of the Bridge Academy. But there's a number of individuals that fall in this category, for example, that were either terminated since or have been terminated recently, and we have also put them in the not certified category. I'll just note that there's still a bit of analysis being made, with some of these records, as we have certain validation, the need to do some validation in some of these records, and those are the 44 records that I'm reporting in the second column. We will be taking the matter of dissemination of information very, later in the meeting, in the regulations that are also in the packet. But I wanted to mention here, commissioners, that the details of these, the names associated with each of these categories is a matter of great public interest. Needless to say, there is that this is for the public in general, but it's also true for the agencies who want to verify the status in some cases, or where there's an individual who may be transferring, being hired by another agency, for example. We continue to get questions about the status of this certification, and we can talk more about this when we get to the matter of the dissemination of information. But I want to highlight the certified category, the 8,134 individuals. We have a very high degree of confidence that they have met all of the requirements in the statute. And those, my proposal to you, commissioners, later will be that if you're comfortable with the way the regulations read, that we begin to make the list of those individuals, at a minimum, those that are certified, begin to make those records public. Again, it is a matter of great public interest. We have gotten a number of public records requests, but it's also not just from the public in general, but also from agencies. There are, I should say, and I would hold off on reporting where we continue to make progress on categories like those meriting further review, and we can talk more about that process if you so wish. I'll come back at the end of the next couple of slides, but let me turn it over on the next slide, and I can navigate, Eric. Our CFAO, Eric Rebello-Pradas, is going to take the next two slides to talk about the closing of the fiscal year, where we stand in general, and where we're going in terms of next fiscal year.
Thank you, Enrique. Good morning, everyone. Just a quick finance and administration update. FY22, the books of the Commonwealth officially close October 31st at the end of the month. So our final expenditures were just a hair short of $2 million for that fiscal year. In line with most state agency budgets, the majority of our expenses were concentrated in employee compensation at about 42% of the budget. In addition to the 9 commissioners, there were 14 staffers that were employed with post as of June 30th. So that's as a total of 23 employees. The second highest expense was the consultant services with such as legal and media affairs, very consistent, obviously, with a startup. And then, of course, the third being IT. Most of that money in IT was concentrated in the interim JIRA solution. In FY23, we have now just completed the, excuse me, we have now just completed the first quarter of financial activity. It is still early with the fiscal year right now. However, we are trending below projections, thanks mostly to onboarding the delayed onboarding of new hires. And that has actually also led to we had identified an exposure at the beginning of the fiscal year, right around the beginning of July, about $150,000 in a payroll exposure. We thought we were going to go over, but with all these delays, that actually has somewhat mitigated that exposure. So it's pretty much something that we are not too worried about anymore. And that's kind of what we were projecting at the beginning of the fiscal year anyway. Salesforce development. This is our major IT solution that we're working on right now. Everything's embodied in Salesforce. We are in the 7th of a 7 weeks sprint or task order. This is the first phase. And right now this was valued at about $362,000. Right now we are trending slightly below that amount, but we are keeping a very close eye on the hours that are being worked, the money that will be going out the door, and making sure that the product is going to meet all of our expectations. So we are in the midst of drafting the second phase, the second task order, which will probably get us through the end of December or early January. Just to let you know as well, everything that I've gone over here is also detailed in the accompanying memo, as well as a financial report. And then just quickly, we are tracking a $500,000 IT exposure. Please keep in mind, this is a worst case scenario, and this is only if our tracking of the Salesforce development, the pace suddenly kicks up for whatever reason. So we're just keeping it as conservative as possible so that we can just be aware of any, we want to be prepared for the worst and of course hope for the best. The next slide, thank you. The annual report, we're actually making a lot of progress on this, our inaugural report. The first draft is expected by the end of this week. Obviously, we'll go through multiple revisions and edits through the end of the month. And then we are expecting to have a presentation, the final report, to the commission for your November meeting. And just as a reminder, this covers all activity for FY22. Just real quick on the FY24 budget development, Ali and I have concluded a meeting with all of the division heads of Post to get their inquiries and feedback and data sets for coming forward for the next fiscal year, which we're already starting the development for July 1st of 2023. So the next step right now is we're working on making a lot of comparisons to similar agencies throughout the state, as well as other post type agencies throughout the country. And that's it.
Thank you, Eric. And as I mentioned, Madam Chair and Commissioners, I'll just give you verbally a brief update on the hiring. I neglected last meeting, the September meeting, even though 2 individuals had already started with us in the prior days. I neglected to mention them, and I want to mention them now. Sean Martinez is joined the Division of Standards as an enforcement counsel, and John Polillo as an investigator and compliance specialist. Most recently, Tim Hartnett has also joined the Division of Standards as an enforcement counsel, and Owen Mail has joined us in the technology field. He'll be helping manage the 3 large projects that we have that Eric touched on as we transition away from the interim solution in JIRA into the Salesforce development over with our vendor Slalom, and the ongoing disciplinary records efforts. If I may just go back briefly to the second slide, just want to put in context of the final results and the upcoming year. The $2 million, the $199 million that effectively closed fiscal year 22 is maybe a little bit deceiving, because we incurred and encumbered and had to encumber a number of costs that had started then, and we're going to actually expend them in the fiscal year 23. That gives, in a great way, that gives the genesis to the potential exposure, but in the IT field, but we'll continue to manage the way Eric stipulated on a task order basis on whatever scope we can have in that large contract, because we have quite a bit of functionality that is needed, but we also know that there's a lot of things that move in between those task orders. And we are already, as Eric mentioned, started the process of the fiscal year 24 budget development. So we will be much closer to $8 million or so, which is where we're trending right now, for the fiscal 23 budget, or greater for the fiscal year 24. This really reflects the ramp up that is happening as we speak, with people joining, with the technology projects now being gaining a lot more momentum. So let me pause there, Madam Chair, and ask if the commissioners, if you or the commissioners have any questions about anything that we are reporting.
If I might just thank you both for your reports, and I have a question. Eric, you mentioned that in working on the next fiscal year budget, you are meeting with division heads. Are you talking about certification and standards, or are you grouping something else into that category?
In addition to certifications and standards, also communications, legal, technology, and then of course, finance and administration, which would, yes, and finance and administration. So basically all of the senior staff that reports to the executive director.
Thank you. I think Commissioner Bluestone and Commissioner Luma both have questions. May I start with you, Commissioner Luma?
Sure. Thank you. Eric, can you just remind me of the status of the rollover?
Sure, of course. So the governor included in his final SUP, or I should say final deficiency supplemental budget for FY22, he filed it on August 31st. He included the $2.9 million rollover within that. He also urged the legislature to act on it quickly. The comptroller always gets nervous around this time of year because he needs to close the books by October 31st. The legislature lately has been, last few years, has been late in passing this final deficiency legislation. So we are hoping they'll act on it before the 31st, but it could be delayed, and we are expecting that that may happen.
Thank you.
Of course.
If I may just expand a little bit on that point, Commissioner Luma, we are proceeding, assuming that we're going to get that rolled over and assigned to us. The need is very much there. I alluded to the fact that we had incurred a lot of those costs, effectively committed to them the prior fiscal year, and we are spending with the assumption that that money will be available. And we'll have to do, if in the very worst case scenario, the very low probability scenario that it is not, we will have to, react accordingly.
Right.
Commissioner Bluestone.
Thank you, Chair. Enrique, I would just wanted to ask a little bit more about the issue of how officers are being categorized into the not certified category. And you said, quote, we have put them in the not certified category. Could you just explain for me again, who's making that determination? I think that there's a group that is not certified due to training issues, and then you referred to some other individuals, and I'm just wondering how that determination is being made.
Yeah, thank you, Commissioner. Well, as per our regulations, that determination is made initially by the Division of Standards. I'm sorry, the Division of Certification. So that would be Stephen Smith, in consultation with people with the Division of Standards, because they also review, and we've been doing this as a team. As per our regulations also, and which is something that we are implementing as we speak, and we will come with a detailed plan of those procedures for you next meeting. Individuals who want to have that be reconsidered have the ability to have two levels of review. They can ask that the review be made by myself, the executive director. And in the case of still negative determination, for example, they have the second level of review, which would be yourselves, the commission. We have to consider that process will merit very detailed procedures, notification issues, will adopt procedures for hearings, for example. And as we are finalizing those procedures to bring before you, so that we can deal with those cases, what we anticipate to be a first, or in some cases, a two-level review process.
Thank you. I would just mention that I see both, from the community side and also from the law enforcement side, a tremendous amount of anxiety about when those determinations will be made. Do you have a sense of the timeline on that?
Fortunately, I don't. We also have we understand that there's a lot of anxiety, and we also need to be thorough. So we are proceeding as fast as we can. That allows us to have good, robust due process. As I mentioned, working on what we believe will be a solid plan that we can put in front of you at the next commission meeting, which will continue to make the incremental progress that we need.
Thank you.
Commissioner Ellison, please.
Yes, Madam Chair, thank you. I just wanted to echo your sentiments there, as my time as the treasurer in the commission, the director and Eric's team, and keeping me updated on the treasurer and what's been going on. And I think you'll see that come out when they present their report to the full commission at the next meeting. So I just wanted to say thank them as well for the hard work and for keeping me in the loop.
Thank you, Commissioner.
Absolutely. Thank you.
Are there any other questions or comments on what Eric and Enrique have provided to us? Let me also echo the same thanks that Larry just stated, and I know I speak for all of the commissioners when I do that. If not, and I don't think I see any other hands in the air, I believe we can move on to item number 4 on our agenda, the General Counsel update. And I turn this now over to our General Counsel, Randy Ravitz.
Thank you very much. I believe that the first item on the agenda under that portion is the regulations concerning databases and the dissemination of information. I will show those regulations now. What you're seeing is a version of the regulations regarding databases and the dissemination of information that was presented twice before in public commission meetings. But this version shows the changes that were made since the last commission meeting. Now, all of those changes, except for any changes related purely to formatting, are reflected in redlining. But there's also highlighting added to the changes that I consider to be significant. The other changes were mainly made for purposes of clarity or consistency or to correct typographical errors. I'm happy to answer any questions about those, of course, but unless there are questions about those, I'll just focus on the ones that are highlighted. So the first highlighted addition is item number 11, and that provides for the database to include information regarding a reversal, a vacation, or an exoneration related to any form of information that is listed above within one of these categories of information that would be included within the database, or that's otherwise included in the database. And this was added in response to comments made at the last commission meeting. There was also a proposal at the last commission meeting to incorporate the phrase included but not limited to in this. You won't see that phrase here, but that's only because section 8.058 below makes this list of items non-exclusive. So that concept applies to everything on the list. This next phrase was added just to account for technological uncertainties. Right now, the intention is for the database to enable users to aggregate data. In other words, to type in, let's say, the name of a particular city and get all the officers within that city, or to request a listing of all the officers who have been decertified and to have the database generate that list. But we just wanted to account for the fact that all of this is still being developed. Sometimes technological solutions do not work out the way that people intend. And so this is added just to cover that possibility. Next is another set of additions that were incorporated in response to comments made at the last commission meeting. And this section that you'll see here includes some language in addition to the language that was inserted in the version that was circulated to the commissioners most recently, just to account for some additional feedback that we received. With this new language, whenever the executive director grants a petition, and that means a petition seeking a change to the information that's in the database, or challenging the information that's in a commission database, whenever the executive director grants such a petition and thus makes a change to the database, or whenever the executive director denies a petition and thus makes no change, information on the action taken would be made available to the commissioners, and the chair would be able to take any steps deemed appropriate. And this procedure is intended to balance the interest in commissioner oversight with the interest in flexibility, because at this point, there's some uncertainty regarding how many of these petitions we can expect to get, and the possibility that many may involve smaller, uncontroversial matters. And just by way of illustration, since notifications have gone out to people, some people have reached out to the commission to say things like, my certification has my nickname, but this is my full name, or my middle initial is off. Things of that nature. If we see things like that are minor and that could be corrected easily, this would allow for those to be dealt with without necessarily encumbering the commission's time, but yet it would still make all this information available to the commission so that it could be taken up if commissioners are concerned about anything. So that covers these highlighted changes. And then this phrase that's highlighted here, that is maintained by an employer, was added to make clear that this provision concerns an employer's personnel record. There was a question about that at the last meeting, and I responded to that this provision is designed essentially to require the commission to hold off if it has reason to believe that there's information in an employee's personnel record maintained by the employer that the employee has the right to have corrected or expunged pursuant to the statute that's cited there. And so again, that phrase was added just to make clear that that's what that provision deals with in response to a question that was raised at the last commission meeting. So those are the changes that I would see as significant. But again, I can answer any questions if the chair would like me to do so related to those or any other matters in these regulations. And we we're hoping that the commission might be able to take a vote toward promulgating these regulations at this meeting. That would, of course, require certain steps to be taken before the promulgation becomes official, and those steps would provide for notice and comment to the public, and the ability for the public to provide feedback and for us to take that into account. So it would just be a first step in that process, but that is something that we thought might the commission might be ready to take at this meeting.
Thank you, Randy. Let me ask of my fellow commissioner if he has any questions or comments for you. Don't think I see any. Enrique?
Yeah, I see Commissioner Calderon raised his hand. He may be off your screen.
Sorry, I apologize. I didn't see that. Yes.
No worries at all. Thank you, Madam Chair. I just want to take an opportunity to say thank you to everybody, including Randy, who I know is doing all this work behind the scenes of putting the documents together. Very thankful for the members we represent for keeping in the exonerations and the changes to the findings as they go forward, and also being able to create a method of objection when the data within departments are not kept concurrently with that of the post. It seems to be a sticking problem here in Boston. So just wanted to take the opportunity to say thank you for the work that was done to everybody involved. Appreciate it.
Any other questions or comments from any of the commissioners? Let me once again echo Commissioner Calderon's thanks, Randy, for you and the other staff members who have worked so hard on these draft regulations. I would at this time entertain a motion to promulgate, pursuant to what our general counsel has just said, these draft regulations on databases and dissemination of information. Is there a motion to that effect?
So moved.
I'm sorry. Was it Commissioner Wynn?
So moved.
Thank you. A second to the motion, please.
Second.
Thank you, Commissioner Luma. And any other questions or comments? If not, let me call for a vote. Commissioner Bluestone,
I approve.
Mr. Calderon,
Yes.
Commissioner Ellison,
Approved.
Treasurer Rosen,
Yes.
Commissioner Luma, I know you seconded, but formally. Thank you. Commissioner West,
Approved.
Commissioner Wen,
Yes.
and I also approve. Those members of the commission in attendance have unanimously approved the promulgation of the draft regulations on databases and dissemination of information. Again, thanks to those who have worked so hard on this. Next item on the agenda, please, the proposed amendments to the use of force regulations, and back to you, General Counsel.
Thank you. I am now sharing a document that was distributed to the commission previously. And just by way of background, the Post Commission and the MPTC jointly promulgated regulations, as you know, concerning the use of force by law enforcement officers. And they adopted emergency amendments to section 6.046 of those regulations in order to leave no doubt that an officer is prohibited from taking certain actions that involve placing pressure on an individual's neck or head, and an exception in the regulations that in certain ways gives officers more latitude when they seek to temporarily regain, or maintain control of an individual and apply restraints, does not relax that prohibition that I just mentioned. The agencies have taken since then the necessary steps to enable them to make the regulations permanent. Most recently, they held a joint public hearing and received written comments. The comments from the public did not concern the amendments, but instead concerned one aspect of the definition of de-escalation tactics within the regulations and the previously discussed Section 12 issue. But the agencies heard no reason not to promulgate the amendments on a permanent basis. So this approval would authorize that, provided that the MPTC authorizes the same. And this document just recites that background information and sets forth the approval that the commission is being asked to adopt today.
And let me inquire whether there are any questions or comments. Yes, Commissioner Calderon, please.
Yes, again, Randy, if you can clarify, I'm a little bit confused, I apologize. So on that brief that you have on the screen, does this include then the Section 12 discussions that we're having, or is that at a later date?
This makes no reference to the Section 12 issue. This would only concern the amendments made to the regulations regarding pressure on the neck and the head.
Okay, thank you very much. Appreciate it.
Commissioner Ellison, please.
Yes, also, Randy, you know, as Commissioner Calderon alluded to as well, is this going to be part of the MPTC training? Because a lot of departments train in different manners, and like the issue is, for me, it says shall not force an individual to lie on their stomach. Some departments, that's how officers have been trained. And if it's been changed since I went through the academy, it's totally different from what the regulations are going to require as to what the training has been for officers that have been on as long as I have. And what I mean by that is that this would seem normal for veteran officers who have not received any additional training or MPTC guidance as it relates to putting someone on their stomach in that prone position.
Well, I'm always wary about speaking for the MPTC, but my understanding is that their training includes addresses the use of force and therefore these regulations.
Because my concern is it almost seems like a one size fits all, and it just in real time and in real situations, it just doesn't always apply. And having an officer having to struggle with that, if they have to put a person in that position and then be held accountable for something that just was unavoidable.
And may I ask Commissioner Wynn, who I think is
if I can just respond to Commissioner Ellison. So just to remember that this is an amendment to one sentence in the regulations that we already voted and adopted to approve. We, in joint conversation with the MPTC, we anticipated that temporarily proning somebody out was always going to have to be allowed. So if you look at the beginning of the paragraph, except to temporarily gain, regain, or maintain control of an individual and apply restraints, that's not changing.
Okay.
We're just saying that you can't deliberately sit, kneel, or stand on the head or neck. That's the clarification.
Got it. Okay. Thank you for that.
any other? Yes, Enrique, please.
Yeah, Madam Chair, I just wanted to provide additional background. We did conduct the hearing as required on these regulations this past Tuesday. Although we had a couple of comments, and Commissioner Calderon and Commissioner Ellison joined me in presiding. We did have some comments, but they were not related to the change in the regulations, which is what, you know, why we come here to give you the update as well. The comments continue to be around some clarification of the rest of use of force sections, notably, as Commissioner Calderon alluded to, one about Section 12 and another about somebody passively resisting. But suffice to say that we can come back to you if later if we think some of those comments merit additional discussion. But when it comes to the proposed amendments, there are no relevant comments.
Thank you. Any other questions? If not, is there a motion to approve the proposed amendments?
I'll make that motion to approve it.
Thank you, Commissioner Bluestone. Is there a second to that motion?
I'll
Second,
second.
I know, I heard Commissioner Kajrosian, and who else was it? Thank you. Any additional questions or comments before I call for a vote? See any hands in the air? Commissioner Bluestone,
I approve.
Commissioner Calderon,
Yes, approve.
Commissioner Ellison,
Yes.
Mr. Kajrosian,
Yes, approve.
Commissioner Luma. You're on mute.
Oh, she can't get off of mute.
Thumbs up looks like yes, yep.
Thank you. Commissioner West
Approved.
and Commissioner Wynn.
approved.
And I also approve, so those in attendance unanimously approve. And again, thank you, those who have worked on the proposed amendments. And let me move on now to item number 4C, the draft regulations for certification of school resource officers. And back to you, please, General Counsel.
Thank you. What I'm showing now is a draft set of regulations concerning the specialized certification for school resource officers that is provided for in section 3B of chapter 6E. And as with the other set of regulations, this version shows changes that were made since these regulations came before the commission at its last meeting. It shows all changes in redlining, but I've highlighted those that I would consider to be significant. And again, others were generally made for clarity, for consistency, or to correct small errors. But I'm happy, of course, to answer questions about any of the changes. I will focus, though, on the highlighted parts. In this definition, and this is something that I discussed last time in response to questions that were raised. In this definition and section 10.04 below, which I'll show in a moment, clarification is provided regarding the issue of when an officer is and is not required to obtain certification to perform school-related duties. And I just want to show the definition of school resource officer that is found in the relevant statute, which is another part of the general laws, chapter 71, section 37P, that's incorporated into section 3B of our statute. With that definition in the statute with red showing how this definition to the left differs. And hopefully the takeaway will be that this definition to the left provides some clarity, but in a way that does not change the substance of the statutory definition and that stays true to the statutory definition. So in other words, it doesn't take any undue liberties with that definition. So here's just an introductory phrase saying it's an individual. The statute uses the word or here, so it basically provides two different definitions. So this definition to the left just inserts the A and the B in order to make that clear and make it organized. The statute uses the phrase a special officer. And one police chief at our last meeting entered a comment in the question and answer area of the Zoom platform to the effect that the term special officer is unclear because it's used in different ways. And that point is well taken because in fact, the Massachusetts Appeals Court in a decision just last year made the same observation. The term special officer is used in very different ways. throughout the general laws and just throughout practice. And so a change was made here to try and capture what it appeared to be that the legislature meant, which is an officer appointed by the chief of police who is specially charged with performing the duties that are listed in the statute. Now, this list of duties uses the word and there are quite a few judicial opinions that stand for the very obvious proposition that and really means and, it doesn't mean or. So where a list like this is provided, it means that everything on the list needs to be satisfied in order for that provision to apply. So this just adds a phrase to that effect. It eliminates this language, doesn't substantively eliminate it, but it just doesn't include this language that is found at the end of the statutory definition, simply because that language appears to be more of a substantive provision as opposed to a true definitional provision. And basically what it provides is that this other statute that restricts the carrying of a firearm in a school does not apply to school resource officers, or that they're exempt from that provision. So this definition to the left, it doesn't reference that, but it also doesn't detract from that. It just limits things to the definition. And I'll note that I had mentioned that there are two different definitions set forth in the statute. The first definition of SRO extends to somebody who has special SRO certification. So for our purposes, where we're trying to figure out who needs to get special SRO certification, that definition really drops out. It doesn't have relevance. It's not useful to us. The focus is really more on this second definition. And that brings us to this section of the regulations that was added since the last time. And it incorporates that second definition that I mentioned. So what it provides is that an SRO certification, meaning this specialized certification, is necessary in order for an officer to serve in the position described in that second definition above, which involves all three of those listed duties, or in a situation where the individual would be holding him or herself out as an SRO, representing themselves as an SRO. Then a certification would be needed in order for the officer to do that, but it would not be required otherwise. And that's significant because there have been questions raised about things like an officer who is called to a school to respond to an emergency situation, but is not regularly at the school, or an officer who goes to a school once in a while to, let's say, speak to students about safety precautions or about careers, but they're not regularly involved in the school. They don't perform all of those duties that are listed. They don't hold themselves out as a school resource officer. That officer under these regulations would not need this specialized certification. So just moving down to the next significant change. There were in the earlier draft, two requirements that I suggested at the time could be cut, and there was a response from within the commission that would be a good idea. And those two requirements would have provided that in order to get a certification, an officer needs to show that the operating procedures adopted by the school system and the memorandum of understanding between the school resource officer and the school system, that those are satisfactory, those are sufficient. And these were cut basically to keep the focus on the individual, whether that individual should get certification. As to whether the arrangement between the individual and the school system is sufficient, it'll still be evaluated, but it would be evaluated by other people. It wouldn't be necessary to get this specialized certification. And some other changes are made in this section and elsewhere in order to strengthen the provisions in these regulations regarding the need to obtain SRO training. So for example, here it states that if an officer who's seeking SRO certification has not completed the training, they should explain why in their application. This provision that's highlighted here, as well as one found below under section 10.11, are intended to encourage agencies to line up alternate SROs in case an SRO cannot serve. And that's partly because there should be a way to enforce the provisions of these regulations while minimizing any inconvenience or adverse impact on agencies and schools. So this is one way that's built into the regulations. It encourages agencies to, as I say, to line up a backup individual who could step in if, for example, an officer loses their certification or they're temporarily suspended because they have not completed the training requirements. Now, here too, this just carries forward a change that I mentioned above, which is that the certification process would not look at the sufficiency of the arrangement between the SRO and the school system. It would just look at the individual. Here you'll see a lot of red, but these changes were really just intended to make things clearer. It, for example, reordered some things, but the changes largely are not substantive or significant in my view. However, this part that's highlighted here, as well as provisions of section 1010 below, which relate to in-service training, were intended to allow for flexibility. And again, partly to facilitate the enforcement of the regulations without adversely impacting agencies and schools. So if an officer has not completed all SRO training, the division would require that to be done as a condition of a conditional SRO certification, and that it would need to be done within a reasonable and specified period of time. So again, it provides for an enforcement mechanism, a way to ensure that the standards are satisfied, but to do it in a flexible way. These provisions too, regarding in-service training, they're intended to strengthen the in-service training requirements while allowing for flexibility. And they largely borrow from from section 9B in chapter 6E, which spells out what happens when a serving officer has not completed in-service training. And that statute provides that an officer can be administratively suspended, but essentially there's a 90-day grace period, and exceptions can be made for situations where an officer faces hardship, for example, and cannot complete the training. And then once the officer does complete the training, that suspension automatically ends. So this would provide for similar provisions related to specialized SRO certification. Once again, as I mentioned above, this is a section that encourages agencies to line up alternate SROs. It doesn't require it because different agencies have different resources. And finally, is a provision that allows for certification in subspecialties. So for example, sexual abuse or trauma or civil rights, those are just possibilities. But this is phrased in general terms to, again, allow for flexibility, especially as these subspecialties have not yet been defined. And this is all a new process. So it allows for the future development of this type of specialized certification. And I can answer any questions if the chair and the other commissioners would like me to do so.
Commissioner Ellison, please.
Yeah, Randy, thank you for that. And thank you for allowing my input during this process. So in that last paragraph that you were referencing, let's say, for instance, an officer that was just transferred into a unit and the training wasn't available because of scheduling, would that officer be allowed to operate in that capacity as a resource officer if it went past that 90 days until the next training was available, to be able to function in the role as an SRO?
Well, this provides for, here, I'll just, if I could just show that again.
And my reason for it is because a lot of the training is scheduled at certain times of the year. And if you miss that cycle and you get transferred from one unit to another, it may not be within that 90-day time frame for the officer to receive that required training.
So really, that's evaluated in two different ways. One is when the officer is first seeking the SRO certification, what the regulations would provide is that if the officer hasn't completed the specialized in-service training, the officer can still be certified, can still get that specialized SRO certification. It would just be on a conditional basis, and the condition would provide that it be completed within a reasonable and specified period of time. So there's not even a set time period spelled out here. The idea was to accommodate situations where maybe just as you said, there might not be training available right away. Then the second point at which this could be evaluated is while the officer is serving. And so what it says is, if an officer fails to complete the training within 90 days, so there's already that 90-day grace period built in, but then even then it says the division may administratively suspend the officer's SRO certification. And that was, again, based on what we see in section 9B, where it says exceptions can be made and it lists some reasons why exceptions can be made. This was intended to allow for exceptions to be made and not even necessarily to limit it to any particular reasons, but just in any situation where the division would not find it appropriate to administratively suspend the officer's SRO certification, they can hold off on doing so. And again, even then, once the officer, even if the officer is administratively suspended, once they complete it, they would be reinstated, or their certification, I should say, should be reinstated. And I should also note that this would not affect the officers, what these regulations refer to as officer certification. So the main general certification as a law enforcement officer, that would not be suspended just because they have not completed the specialized SRO training. So is that helpful?
It does. And one other question, Randy, on the MOUs, right? Like, for instance, Boston still doesn't have an MOU with the schools here. So would this policy be able to be implemented by the officers who have received the training if the MOU has not been satisfied? Would they be, because that's a question we get lots of officers, are they in violation if they've got all their certifications, but the MOU still has not been ratified? Are they in violation because the MOU still is outstanding?
Well, this would allow them to get this specialized certification if they themselves satisfy all the criteria. They can get this certification. Now, as far as whether they should be serving as an SRO where there's no MOU, that part of the statutory scheme is primarily enforced by other agencies, by the Department of Elementary and Secondary Education and by EOPS. So this set of regulations essentially would not get into that issue, and it would just focus on the certification that the commission has the ability to grant.
Thank you.
Commissioner Calderon?
I'm good, Madam Chair. I think Larry Ellison covered everything. Appreciate all the answers, Randy, too, especially 10-4, taking into consideration the language clarification for SROs across the Commonwealth. But I'm good, Madam Chair. Thank you.
Thank you. Any other questions or comments? Randy, are you anticipating that we would, with regard to these draft regulations, we would have a vote today?
Well, if it's acceptable, it seems like it would be ready for a vote, and that would allow for some administrative convenience in that the process of promulgating these can be joined with the process of promulgating the regulations regarding the database and dissemination of information, so they could be put on the same track as far as a hearing and so forth. So I would ask the commission to take up the vote if that's all right.
If I could just one follow up, Randy, just so that I'm clear before the vote, is that language in there would be as soon as reasonably possible? Is that what's already in this language?
Okay.
So I heard you mention it. I just want to be clear that is the language.
Now where what section are you referring to?
It was, I wrote it down. I believe it was section 10, I believe it was, where it had to do with the 90 days, the deadline. You look at it right, section 10:10. The deadline to complete the division make administrative suspending officers SRO. But I heard you mentioning that the language, and I think that was appropriate, as soon as reasonably possible.
I think what I was referring to was the section above that says within that the training should be completed within a reasonable and specified period of time as a condition for this new certification. So that really applies to the excuse me, the initial certification decision. Yeah. However, something like that could be incorporated into the section on in-service training.
That would be helpful. I think it would clear up a lot of confusion for someone new. It would help me, put me at ease a little bit more about the time frame, the reasonably language in there.
I'm just, if it's all right with the chair and the other commissioners, I would just insert something here.
Yes.
Within, now, Commissioner, what was the phrase that you used? Within a?
As soon as reasonably possible.
Is that, does that
yes.
look acceptable to people?
Commissioner Kazarosian?
I didn't, is it necessary to take out the 90 days, or can we say within 90 days or as soon as reasonably possible thereafter? It's like that, I'm not sure we should take out that 90 days because it's to make it consistent throughout, but then to give the additional time if
I think that's a perfect compromise. Yes. I would agree with that. Thank you, Commissioner.
Commissioner Wynn?
Sorry, I just want to ask a clarifying question because I think I lost track of this. The section that we're looking at and Attorney Ravitz is amending is 1010, in-service SRO training, which applies to previously certified, specially certified SROs. If I understood Commissioner Ellison's question, he's talking about an officer who does not possess an SRO certification, who was transferred into a school division at a time that the training's not available. So he's talking about initial certification for the specialized SRO certificate and having a reasonable amount of time to complete the initial training required for initial certification.
That's correct. Yes.
We're in the wrong section.
Okay, well, as far as the initial certification, what it says is that it shall be required to be completed within a reasonable and specified period of time. So that does build in that concept.
And
So
that would
now-
be,
yes,
and that would be specified on their conditional SRO certification.
yes.
I think that's what Commissioner Ellison was asking about.
Yes,
Okay.
that is correct. Thank you, Commissioner, for that correction. Yes.
Okay, then that just raises the question of whether the commission would want to add something along these lines to this part about in-service training, or whether that's not necessary. And by the way, while other people were talking, I added these words within 90 days of any deadline, just to make it clear what we were referring to. But the way it was,
Just to follow up on Commissioner Ellison's concern in that, while the MPTC is still in the process of developing local school resource officer certification programming, and we're relying on the National Association of School Resource Officers for scheduling, I think that having that reasonable term in there is just prudent in case we don't gain control of that schedule.
In other words, Commissioner, when you're suggesting just leaving it as modified,
Yes,
this 10-10. And any other questions or comments on that? Don't think I see any other hands in the air, although I cannot see everybody. I would at this time, consistent with our discussion of approximately 5 minutes ago, simply entertain a motion from any commissioner to approve the draft regulations for certification of school resource officers as modified.
I
Fire.
move to approve.
Thank you, Commissioner West. Is there a second to that?
I'll second.
Thank you, Commissioner Ellison. Any other questions or comments? I don't think I see any hands in the air. Let me call for a vote. Commissioner Bluestone,
I approve.
Commissioner Calderon,
Approved, yes.
Commissioner Ellison,
Yes.
Commissioner Kajarosian,
I approve.
Commissioner Luma,
Approved.
Commissioner West,
Approved.
Commissioner Wynn.
approved.
I also approve. The motion is unanimously carried by those in attendance. Thanks to all who have worked on the drafting of these proposed regulations. Let me move on now to item 4D on our agenda, the presentation on Constable certification. Back to you, General Counsel.
thank you very much. In this case, there's no request for action by the commission at this meeting. Rather, this presentation is intended to highlight an issue that's become apparent and that has been called to our attention and been the subject of discussion and public comments, and that is the certification of constables and their continued service under Chapter 6E when Chapter 6E applies to them. So this, as I say, this presentation just highlights certain issues regarding that matter. The first issue, and I should say that it's highlighting these issues on the idea that if members of the commission or members of the public have thoughts about how these issues can be addressed as we continue to work with the MPTC on addressing them, we'd be very interested to hear any ideas. But we look forward to obtaining feedback from within the commission, from the MPTC, from those in the constable community, and from any others who are interested. The first issue is when and how constables are made subject to Chapter 6E. Section 1 of the statute includes a constable executing an arrest for any reason within the definition of law enforcement officer or officer. And as you'll recall, the commission construed that phrasing to apply to a constable who executes or expects to execute arrests. And that makes sense because it helps to avoid giving a constable essentially one free arrest. That is, it avoids saying only after executing that first arrest does a constable become subject to Chapter 6E. It provides that the constable would be subject to Chapter 6E even in performing that first arrest. But that raises some questions in implementation. How can one know that a constable expects to execute an arrest? And does the commission have to attempt to assess that and to provide advice for each constable on an individual basis beforehand? And is that practically feasible? So there are some potential approaches that could be taken. And one is to provide for constables to affirmatively apply for certification, or at least where they seek the power to make arrests. And then they would be essentially signaling their own expectation of making arrests and their interest in obtaining certification and essentially placing themselves within the statutory scheme. And this would provide a method for them to do so. And then if a constable is certified, the commission can grant approval for the constable to make arrests. But if the commission is not certified, then the constable could be denied the ability to make arrests. So in other words, the commission could provide that if the constable makes an arrest without having that certification, the constable would at that point be subject to Chapter 6E, but also in violation of the legal scheme established by statute and regulation, and that there could be consequences as a result. The second issue is how the certification process for constables should proceed in light of their independence. The process that's been developed so far relies in large part on cooperation from employing agencies. But constables typically are not employed by law enforcement agencies. They're independent. They may have been appointed or elected by a local authority, but they're not employed by a law enforcement agency. So they don't fit squarely into the certification process that's been developed so far. For example, how would a background check be conducted? How would an oral interview administered by the commission be conducted? How is the character and fitness standard assessed? Those are all mandatory requirements for certification. And you can see how it becomes trickier to apply those when somebody is not employed by a law enforcement agency. The other standards are much easier to apply. So one approach would be to develop a certification process that's tailored to constables and their independent status. And such a process could borrow as much as possible from existing regulations and policies regarding certification, including their requirements, and also the protections that they include, and the ability for officers to obtain, in this case, constables to obtain conditional certifications. And it would allow such a process for them to apply for certification independently, not going through any other agency. And it could address those three criteria that I mentioned a moment ago by, for example, requiring them to secure background checks from the commission or a law enforcement agency, perhaps for a fee, by designating officials who may conduct oral interviews and providing guidelines for those interviews, and by requiring constables to submit letters from officials who can comment on their character and fitness. So in other words, finding substitutes for the procedures that have been developed so far for those who work in agencies. The third issue is ways in which constables can satisfy training requirements. Chapter 6E includes quite a few provisions that reflect an expectation that officers will complete basic and in-service training. And I won't list all those, but that's taken into account in the certification process and as an officer continues to serve. But exactly which in-service training requirements apply to constables, and to what extent are they generally able to satisfy basic and in-service training requirements? How does it work for them? How would it be tracked? So that's an area where the approach so far that's been identified is to continue communicating with the MPTC and with representatives of the constables to gather more information and explore ways of addressing it. So essentially to work with the relevant stakeholders to find the answers to those questions. The fourth issue is the extent to which constables are subject to forms of oversight and consequences that are comparable to those provided for other officers in the statutory scheme. Several sections of the statute provide for officers to be overseen by or investigated by or reported to the commission by supervisors. So those provisions relate to alleged misconduct, they relate to use of force. Some refer to certified officers and some just apply to officers generally. But again, constables do not typically serve under supervisors in a law enforcement agency. Chapter 6E also provides for restrictions on powers and other consequences when an officer has been suspended or their certification has been revoked. But some of those provisions may have less relevance or be harder to effectuate where a constable serves independently. So one potential approach would be to provide that as a requirement for certification, there must be someone identified who would take personal responsibility for overseeing the constable, investigating them if necessary, making reports concerning the constable, the things that are provided for other officers, and that person would perform the functions that are identified in Chapter 6E as being things that are expected of supervisors. So receiving reports about use of force, investigating misconduct, as I mentioned, reporting to the commission concerning allegations of misconduct, results of investigation, uses of force, disciplinary recommendations, and failures to complete in-service training. Those are all things that the statute already provides for officers generally. And making records regarding the constable available for audit or inspection, same way that the statute provides for other officers. And for such a person who serves in this oversight role to be subject to commission jurisdiction or who can otherwise be safely relied upon to perform those functions. That's one potential approach. Another approach is to provide for a constable to be subject to policies that are comparable to those developed for law enforcement agencies and those developed by law enforcement agencies pursuant to Chapter 6E, and to provide for restrictions upon their authority or other consequences if they're suspended or their certification is revoked, again, just as we have with other officers. But at the same time, guaranteeing constables certain rights and protections that are provided for officers under the law where they serve in agencies. So an example is that there's a protection in the statute for those who report abuse by another officer, that they're protected against retaliation, and that there needs to be a policy promulgated by the relevant agency that guarantees that. So building in something into whatever is adopted that would ensure that constables have the same type of protection That's just an example. So once again, this was just intended to identify this issue and its complexities and invite thoughts from within and outside the commission.
Thank you, Randy. Commissioner Luma?
Thank you, Randy. Do we have any data as far as how many constables we're talking about and we should be considering?
That's one of the things that we're trying to ascertain. And some of that is it's not that easy to put one's finger on. There are a couple of organizations for constables in Massachusetts that are long established, but they are voluntary membership organizations. And it's not as though we have access to a list somewhere of all the constables. So that's the kind of thing that would need to be kind of a data point that we would need to work on.
And Randy, relatedly, when you talked about representatives of constables that you have consulted with, that the commission has consulted with, can you specify who that includes?
Sure. A couple of us on the staff, for example, recently met with, and I know that there were meetings a while back between, correct me if I'm wrong, the executive director and Mr. Povich, with representatives of the Massachusetts Constables Association and the Massachusetts Bay Constables Association. And I believe they may have met with the MPTC as well, with members of that agency. Now, that's not meant to imply that those are the only conversations that would need to take place. We look forward to further communications as things are developed, but those initial conversations were helpful in identifying some of these issues that need to be hammered out.
Thank you. Commissioner Ellison?
Yeah, thank you, Madam Chair. Just one quick question, Randy. Do we know if all constables are licensed by one appointing authority, or is it based on an individual city or town?
No, it's done on a municipal basis. And in fact, there are, excuse me, different approaches taken in different municipalities. So that depending upon whether a constable is serving in a city, whether they're serving in a town, the approaches differ. And even within a given town, there can be different approaches taken. So they could be elected, they could be appointed by, for example, a board of selectmen. And there's some latitude in the general laws for a municipality to decide how it will choose constables for itself. So there's a lot of variation from one place to the next.
Thank you.
Any other questions or comments at this point? Enrique, I think I see.
Yeah, if I can just expand a little bit on what Randy already mentioned. My sense is that this is not a very large group, Commissioner Luma, but as Randy just mentioned, there are a number of permutations. There's at least one case that I know of a harbor master who's also a constable. So there's a number of different approaches to some of these municipalities, a couple of times elected, or in some instances appointed by the municipality.
Are there any other questions at this point about constable certification? I think I see any other hands in the air. Let me thank everybody who has worked on everything that we have addressed today. It is clear to me that the staff has been extraordinarily hardworking and has moved as expeditiously as possible to address the myriad of issues that are in front of us at the present time. So I want to thank the commissioners for all of their hard work. Moving on to item number 5 on the agenda, there are not any matters not anticipated by the chair at the time of posting. And so I would at this point entertain yes, Enrique.
If I could come back to something I mentioned in my report, commissioners, I was suggesting that if the commissioners did not object, that we might be able to start publishing the names of people who have been certified, or should we just let the regulation promulgation process on dissemination of information play itself out until we begin making any kind of public information available? As I mentioned, it's a matter of great interest. We feel that if we publish the names of individuals who have been certified, there would be very little objection, very little potential harm. These are all people who have met all the requirements of the statute. We're not suggesting to publish any other categories at this time.
So just to clarify, Enrique, are you making a specific request of the commissioners at this time, recognizing that we have approved the draft regulations on dissemination of information? We've approved that today. And what you are saying is because of the regulatory process, there would be a timetable that would not, without a separate motion, would not address what you are taking up.
That's correct, Madam Chair. I'm suggesting that we might not, when it comes to the category of certified individuals, that we may not need to wait for the regulations to become final, because I see little risk or the possibility of any comments that might make us reconsider at least that classification as part of the promulgation of those regulations.
And I know I see Commissioner Bluestone's hand in the air, but may I just ask our general counsel or our outside counsel, what would the timetable be on the dissemination of information if we do not approve what Enrique is suggesting now? What are we talking about in terms of likely timing?
I think a few months. And I do, since you invited Mr. Povich to offer his opinion, and I think he would he may have some insights as well. I'll ask him if he would like to add anything to that.
Well, given the need for a public notice and a public comment period and reconsideration by the commission and publication at the Secretary of State's office in the Massachusetts Register, I think it's a 60 to 90 day process before things become finalized. And I agree with the executive director's position that on the one hand, there's a decent demand for this list, and on the other hand, it's not the controversial ones that are sort of in process, they're the ones that are done. So it would seem that it would react to a public interest and interest on behalf of the law enforcement community and sort of get the large bulk of officers who are up for recertification sort of publicly attested to without waiting for the final regulation, which really deals with the more sensitive and ongoing situations.
Right. And Commissioner Bluestone, I think you had your hands in the air before Commissioner Calderon, but I will address questions from both of you and anybody else that has any on this particular issue. Yes, Commissioner Bluestone, please.
Thank you, Chair. I'd just like to say that I'm strongly in favor of posting information as quickly as possible, and think it's a good starting point to provide information on individuals who have been certified. Although I would just like to point out that with a database of this size, that I think we need to anticipate that there will be false positives and false negatives. And so I think that, meaning that there will be people that we have certified who we will later find out may not fully meet the criteria or may have some issue that we're not aware of. And by the same token, people who have not been certified for some reason that we may later find out may have been falsely placed in that category. So I think that my concern would just be that where there have been cases where, our team has been making those determinations to place people in the certified category or in the not certified category, even when it seems really clear, that I would just request there be a way for us as commissioners to know that those determinations have been made, because we will all be invited at some point to respond to questions if there have been false positives or negatives.
Thank you. Commissioner Calderon, please.
Thank you. I'd like to urge the, better yet, let me take the stance differently, that I agree with Hanya on false positives or negatives. And I'm already receiving feedback from the law enforcement side of this, of chiefs that have not fulfilled their obligation to notify officers in writing of who is not certified. If we create a list that is incorrect in any way, it will have a tremendous backlash by the law enforcement community. And it will create a tremendous amount of undue stress and anxiety for officers whose names either appear or don't appear incorrectly. I think it is extremely important to make sure that the list is correct, even if that means we take the time necessary to make sure that there are no mistakes in this list that we produce. I don't think that we should be in a hurry to acquiesce pressure that's being given to release names if there's a chance that they're going to be incorrect. It is more important for this body to consider the law enforcement officials that are providing that blanket of safety every day. Their stress and anxiety that's going to be created by this list, if it's incorrect, I don't think we should be rushing. I think we should make sure we take our time and make sure that it's correct before we produce anything. Appreciate the time.
Thank you. Commissioner Luma, please.
Yeah, I echo the sentiment. I would want to know what the validation process is and how we're adding or taking people off. Should we, be certifying people who were not previously certified or they had pending certifications? Are we doing it on a rolling basis? And if we notice that there are errors and then we do take them off, I just want to be sure that, there's a validation process that we feel very confident about moving forward, and we can address any issues that come up in a timely manner, with obviously as much transparency as possible. Thank you.
Thank you. Commissioner Keserosian.
Thank you. I agree with all of the points made, but my concern is I don't know if we're ever going to be perfect when we publish these lists. And no matter how much time or validation or verification, there's always going to be a situation where something is incorrectly published. I can only anticipate that because we're human and things happen. And so I'm not advocating to publish now, but I'm trying to manage my own expectations as well as everyone else's for when this list will ultimately be published. And maybe there's a way to have a disclaimer on there to explain that it's always being reviewed. I don't know how to do it, but I don't think there's ever going to be a time where we're going to have a perfect list that has no errors.
Commissioner Wynn, please. Thank you, Marcia.
Thank you. I'm also in agreement with everything I've heard so far, but again, mindful of the impact on smaller police departments. We already have some experience with the Excel spreadsheets submitted by police departments, then being requested independently of those police departments. And that begs the question, if we go ahead and publish a list of officers who are currently certified, it's going to be fairly easy for people to be identified who are not. And that's going to put an undue burden on the municipalities.
Commissioner Bluestone, I think you were next with your hand this time.
Yeah, I think to sort of take an unfavorable position in this, I agree with Commissioner Calderon and share the concerns of the risks of the database not being completely reliable, but I am in favor of publishing information as quickly as we possibly can.
And Commissioner Calderon.
Thanks again. Yes, quickly and as accurately as possible. And I wanted to echo Chief Wynn. He's absolutely correct. This is going to create an undue burden on those municipalities, and offices then are easily identified as not being recertified. And again, if it's a mistake, it is an undue stress and anxiety pressure that we put on these offices that is unnecessary. I'm sure that we can come up with a better way of checks and balances of that list. Maybe something as simple as sharing that information through this commission first, so that we can do a checks and balances from a chief standpoint, from a labor standpoint. Surely we can come up with a way to make sure that there are as few mistakes as possible. I do agree with Marcia that there's always a chance that something is going to be inaccurate, but why rush? We should do our due diligence and make sure that there are as few mistakes as possible, and create some type of checks and balances. So I just want to reaffirm my position that there should be no hurry to do this. Thank you.
Commissioner Ellison, please.
Yeah, I would be in agreement with the former issues. One being as well is that because there isn't a complete list, one could construe that because we're only doing from A through H. If we sent out a list right now, the general public is not going to recognize that it's not a complete list. And if I'm on the back end of the list, say Williams, you could assume that I'm not certified, but it's just because I haven't been reached yet. So I think the fact that because we don't have a complete list of everyone who has gone through the process, I think it would be prudent to hold off representing that list so people don't interpret it that someone at the back end has not been certified. And it's not that they haven't been certified, they just haven't come up yet.
Thank you. And Commissioner Luma.
So I don't know, I just want to clarify, I am in agreement of a list being published. I just want to understand what the process is. And to be clear, and that's what I wanted to say. Thank you.
Commissioner, thank you. Commissioner Luma. Commissioner West, please.
Thank you. I think Commissioner Ellison makes a good point, but we're going to be in that same situation once we finalize this list, because then you got a whole next set of people who come behind. So I think we're always going to be in that position. I agree. I want this list to be accurate, and I would be fine holding off if I thought, all right, if we did X, Y, and Z, then we would be that much more accurate. But I'm not hearing that. I don't know of a plan or steps that we need to take to ensure that this list is more accurate, would be more accurate in a month than it is right now. And I think we've got an obligation to the public, and they want to see this list, and we need to consider that.
Attorney Povich.
Thank you. I just wanted to throw one more fact on the fire here, not to disagree with any of the points that have been made, but this information is available to the public under the Public Records Act, and the commission and its staff have gotten lots of requests under the Public Records Act, as I understand it, for this type of information. And the database, in addition to fulfilling the requirements of the statute, is a good way to manage that request for public information. So obviously it needs to be in good shape, and as Commissioner West said, it's unclear what more it would need to be in good shape, but it is a valuable tool to deal with the public's legitimate interest in what's going on, and their ability to continue to request such information through the Public Records Act.
Commissioner Bluestone, please.
Thank you, Chair. I guess I'm as I think about this issue, and I recognize that there's a tremendous amount of pressure and fear, but I think that by holding off, we increase the level of anxiety. And I think we just need to acknowledge that there will be some issues that will come up with the database and clarifications that will be needed. But I feel very strongly that the public is entitled to this information, and that we need to get it out as quickly as possible.
Commissioner Calderon.
Appreciate it one more time. Commissioner West does hit a button where she says she doesn't know what more we can do, but I offered one simple suggestion of bringing it to this commission so the body can review it. I know that Commissioner Luma has said that that we need to create some procedures on how this is going to be done. So there are things that we can do. And as much as I agree that the general public is entitled to the information and also under the public records request law, however, I am a police officer as well as the chief and Larry Ellison, and we feel differently. The stress and anxiety that is being discussed here, respectfully, the majority of the people on this thread that are not police officers do not understand the amount of stress and anxiety that is created by a false representation on a database. So we need to do everything we can to protect those that are protecting us and our loved ones daily. And if the general public that's requesting this information can't understand that, I don't know what to say. Apparently, they're not law enforcement officers either. But we do continually hear from department heads, elected officials, and even our own body about stress and anxiety and the mental health and well-being of our law enforcement and public safety officers. That could be no further from the truth than right now. We should be making sure that we do our due diligence to protect those that protect us, take our time and get it as correct as possible. I appreciate it.
Thank you. All of the sorry, I think Commissioner Bluestone again has a question or a comment.
Thank you. Just to be clear, I think we all share that concern, Commissioner Calderon. And I think there's already been a tremendous amount of effort to make sure this database is clean. And I do think that we as commissioners should be aware of any cases where there's any questions so that we're prepared to answer questions if there have been any mistakes. However, in this particular case, we're talking about providing information about officers who have already been certified. And that's what I understand Executive Director Zuniga is asking us to approve. And I believe that we should move forward on that.
Thank you. Yes, Enrique, did you want to add?
I was just going to emphasize that point, Commissioner. As I mentioned in my remarks earlier, the 8,000 plus individuals that we have in the certified category, we have a very high degree of confidence that they meet all the requirements of the statute. So just to address the notion of mistakes, the question of mistake would be anybody who may not be in that list because we're still working our way through, which is a valid point made by a couple of commissioners. But the idea would be that we continue to do that as we work our way through through this list and expand those who end up being certified. I'm happy to just briefly summarize for Commissioner Luma the process that we undertook, or take it up in a next meeting, or just provide a written description. But very, very briefly, we relied on the representation from chiefs in the form of the attestation and the questionnaire that we asked to deploy. And when all of that data was submitted to us, we had a process, an algorithm to validate it, and we have had people who have looked at that all throughout that point and have reasonable, very high degree of comfort level that information is correct. It's a small group that we're still working our way through, those that need further review or may end up being not certified, that we're not proposing to make public. But I do understand the notion that if you're not in this one list and your name is A through H, you might be in that other one. Let me also just mention everybody else, I through Z, and we don't have that roster yet, by the way, but we could get that, is effectively certified by the statute. So when we will be making the proposal that I had for you, commissioners, to make public the list of people that we have A through H, are those that have been certified by this agency for the first time. And we'll continue to do that because the statute required us to just look at them on the basis of their last name.
Thank you, Enrique. And I'm mindful that Commissioner Wynn wants to say something. I would like to, if I could just take a few moments and make my position, state my position to everybody else. I am mindful that we have had a very healthy discussion of this issue that has been raised by Enrique. However, I'm also mindful that we have spent a considerable amount of time on draft regulations with regard to dissemination of information. We've covered that over the course of the last several meetings. We have taken a vote today. We have heard from our general counsel and our outside counsel that it'll probably be 60 to 90 days before those regulations take effect. I'm very mindful of the issues that have been raised, the concerns that have been raised about disseminating information that may not be 100% accurate. And I think given that, my vote today will not be in favor of disseminating the information at this time. I would reconsider that at our next meeting once we have some additional information provided, but I do want to state that at this point. However, I will be mindful of whatever the particular motion is that comes before us, and then take up that motion. Over to you, Commissioner Wynn, please.
Thank you. Executive Director Zuniga addressed some of what I wanted to ask a question about. And I guess my suggestion, my opinion would be that if we get to the point where we authorize the staff to promulgate the list of certified officers, that anything promulgated should include those statutorily certified officers in I through Z and give them the benefit of the doubt as they are currently certified. But I want to direct my attention back that if we take that point, and in large agencies, it's not going to be as simple, but in small agencies, officers A through H who have not been recertified are going to be readily identifiable. And that is going to prompt an assumption on the part of both residents and the media, and then spark a flurry of requests to those departments and those municipalities for any documentation they provided that didn't lead to recertification. And that's an undue burden that will be created by the Post Commission that will have to be handled by the cities and towns.
Thank you. Any other comments at this time? If not, I would entertain a motion. Is there any commissioner who wishes to make such a motion consistent with the request of our executive director? Yes.
I don't have a motion in regards to that, but I do have a suggestion that we identify a date in which we do publish. I think that there's a level of accountability that we do have to the public as far as publishing the list. And I mean, I think we're always going to be in a situation where there are individuals that are not certified that will be easily identified, and we'll have to navigate how to manage that. But I do think that we need to set a date in regards into which we do publish this list. So that's my suggestion.
Yes, Commissioner West.
Thank you. Like Commissioner Luma, I think identifying either a date or an event that would require us then to publish, as I said before, if we could identify certain things, certain actions we could take that would make us all feel comfortable, then I think that would be fine. And I know Commissioner Calderon has made some suggestions. So I agree with Commissioner Luma that it be a date or that it be an action, one way or the other.
Commissioner Bluestone.
I would like to make a motion that we vote today on whether to publish the current list of officers that have been certified.
Is there a second to that motion? Don't think I see a second to that motion. Yes, Commissioner Wynn.
I think we've demonstrated by this robust conversation this morning that this is probably worthy of being placed as a separate agenda item on a future meeting and taking it up as a body after public posting.
Thank you. Enrique, comment?
I was actually going to suggest something along the lines of what Commissioner Wynn said. We can come back with to the next commission meeting with a more detailed description of the process undertaken, a new update, and to Commissioner West's point or one of her comments, one natural event could be targeting when these regulations become effectively, promulgated. That takes us at least as Attorney Pavich mentioned, perhaps 60, but likely 90 days, at which point we will continue to make progress in corroborating and validating these data.
Thank you. Commissioner West?
Thank you. And I appreciate Enrique coming up with something, but I don't think the promulgation of the regulations will necessarily make us feel more satisfied that the list is accurate. So I agree with Commissioner Wynn that this probably needs another discussion, but what I don't want to do is have another discussion in 30 days, not come to a conclusion because we're going to consider what the date should be, and then not make a decision for another 60 days. I think we're just putting it off too long. And so, I don't know what the process could be, but I wonder if we can have this on the next agenda with some options so we can actually vote on it.
Thank you. Commissioner Kazarosian.
Thank you. I agree. I think that's a good plan, but I do think that the point that Attorney Povich made is really important, and that is this is already public record and public information available upon a request. So if someone wants to go out there and get this information, as incorrect as it may be, it's there. So I think if we can somehow at some point figure out a way to minimize those requests and cut them off at the pass by doing some kind of a publication, I think that that's an important goal for us.
Commissioner Ellis, thank you. Commissioner Kazarosian and Commissioner Ellison, please.
Yes, Enrique, quick question. Do we know how many folks we have on the back end that need to be put through the process that are left from I through W? So we have an idea of how many more people. It seems like the bulk were on the front end because of the A through H.
That's correct, Commissioner Layson. Even though it's a third of the alphabet, it's close to 45% of the law enforcement population. What we have now is a good understanding of everybody A through H. We have not asked agencies to submit a roster of all of their individuals I through Z. We could, but we have been plenty busy, of course, with the 8,800 I through H, A through H, I'm sorry, individuals.
Thank you.
Commissioner Calderon.
Thank you, everybody. Healthy conversation, yes. I just want to make sure that we listen to what Chief Wynn did put out there, and Commissioner West as well. I understand the need for movement and time frame, but the chief has the point that procedures should be documented, written, and we should come back and have a public meeting so that the public has a chance to weigh in on this, especially the gallery that we have today. I'm sure that they want to comment and weigh in on it. And as this information gets spread, I'm confident that that number will grow from the general public. So if we can come up with written procedures, come back and have a meeting, have public discussion on it, maybe the commission could come back a following meeting, but somewhat timely to consider what Commissioner West says. So I appreciate everybody's understanding and input. Great point, Chief.
Any other comments or questions? And I think if not, then again, thanks to everybody who's contributed to what Commissioner Wynn indicated was a robust conversation, which I think it most assuredly was. And I think we have direction to the staff in terms of what will be an item on our agenda at our next meeting. And I think unless there are any other questions or comments from any of the commissioners, I would at this time entertain a motion to adjourn.
So moved.
Second.
Commissioner Bluestone,
I approve.
Mr. Calderon,
Yes.
Commissioner Ellison,
Yes.
Commissioner Kazarosian,
Yes.
Commissioner Luma,
Yes.
Commissioner West,
Yes.
Mr. Wynn.
Yes.
I also approve. The motion to adjourn is unanimously carried. Thanks to the members of the public who have attended this meeting. Thanks to the staff and the commissioners for all of their hard work with regard to the issues that have been raised. And I think with that, the meeting is adjourned. Thank you.